Hi everybody, my name is Kevin from IEOR 190G. Topic this week is smartphone patent war, and this week I'm continuing my analysis on US Patent 38104, which is the subject of a case by Oracle against Google, and Oracle claims that Google has infringed on some of the technology within this patent, which originally was part of Java, which Oracle now owns. But Oracle is saying that Google has infringed on some of the technology within this patent, and Google has done so in their Android operating system. So here's how, to recap, here's what the patent says. Looking at Claim 1, this patent basically says that in a computer system comprising a program in source code form, here's a method for generating executable code. So first you generate executable code in intermediate form on a symbolic basis. So you generate symbolic references. B, you interpret those instructions one at a time in accordance to program execution control. Next, you resolve those symbolic references to corresponding numeric references. And then you replace those symbolic references with numeric references. And then finally, you obtain data in accordance to said numeric references. So you take those numeric references that you now have, and the computer, I guess, just takes those instructions and executes whatever it needs to do according to the code. Now, this obviously is sort of technical stuff, and being someone who doesn't have any computer science knowledge, my first instinct is to look online and see what other opinion authors out there have said whether this patent is obvious or not. And I was led to a website called theserverside.com, which is basically like an online website for people who work with Java, people who deal with Java. And so they talk a lot about Java, and so obviously they talk a lot about this patent, which has a lot to do with Java. It was written by James Gosling, the inventor of Java. And the article is called The Oracle-Google Patent Lawsuit Demystified. It's in the description below. Please check it out. But in the article, the author, Cameron McKenzie, talks about this patent, US RE38104. And he says, this patent is basically like a rewording of the IBM RISC patent. So, a little context. IBM RISC was a computer architecture created by IBM way back in the early days, almost 30 years ago. So he says this patent basically seems like a rewording of the IBM RISC patent. In this case, the patent says that if you reference something directly, you can get to it faster than if you reference it indirectly. Or more technically, you can rid your code of symbolic references and replace them with direct references, things that are more efficient. So essentially, this patent says direct references are more direct than indirect references. And the argument that the author is trying to make, and which I agree as well, again, being someone who doesn't know a lot about computer science terminology and things like that, but I can see his point that this is something that's not very novel and not very obvious. And the author of this article also includes a quote from James Gosling, the inventor of this patent, and also the inventor of Java. And the quote from James Gosling really coincides with the point that is being made, that this patent is quite obvious. So, just a second. Sorry. So, James Gosling mentioned that when he worked for Sun, here's the quote: IBM sued over an RISC patent that asserted that if you make something simpler, it'll go faster. Seemed like a blindingly obvious notion that shouldn't have been patentable, but we got sued, and we lost. So even James Gosling, the inventor of Java, claims that, is asserting here that the IBM RISC patent, along with his patent, aren't very novel in the first place. And, here's at least some very strong opinions, and which make a very good case for why this patent may not be so obvious. There is on another blog by a IT expert named Charles Nutter, who I looked up, is apparently the owner and CEO of a company called Hedius, which does things relating to Java, he basically said, the techniques seem obvious to me, but perhaps they're obvious because this patent helped make them standard. What I can say is that I can't imagine a VM in existence that doesn't violate the spirit, if not the letter, of this patent as well. So it seems like the verdict is that this patent is fairly obvious. Whether it is or not, I'm not actually sure, but I think it makes a great case that this patent doesn't really bring anything novel to the table. And so that's basically the stuff that I wanted to present this week. Anyways, have a great week, and talk to you soon.